Took a stand for Stephon Clark, who was killed by Sacramento police in his grandmother's backyard. More recently, he stood up for Sacramento native Tyree Nichols, who died after being beaten during a traffic stop with Memphis police. Now he's been brought in to help represent the interests of a black 16-year-old Missourian shot in the head and then in the forearm after he rang the doorbell at the wrong house. This incident happened last Thursday and has prompted protest and taken root in the national headlines as Ralph Yar's family and many in his community have loudly demanded the kind of charges that were filed in the case yesterday. We are turning to Michelle Trigger of Trigger Law to try and understand more about a case that some say turns completely on a racial component and others say is all about shooter protections contained in stand your ground laws. Michelle, good morning to you.
Good morning.
First, the name is pretty self-explanatory, but please give us a brief overview of how a stand your ground law is supposed to work.
So stand your ground laws, they're not present in all 50 states. They're present in a select few. And essentially what they are is they're codified laws. In other words, the legislature has actually written up and passed these specific laws to address certain issues. Stand your ground is a specific type of law that says that if you're faced with an unlawful intruder, usually into your home, but it can be into a vehicle or your business or your yard, that you can use lethal force against it. Even if the force coming to you is not necessarily lethal, you just have to have that fear, and that allows you to, quote, stand your ground and protect yourself or your family or your property.
Alrighty, in this case out of Kansas City, Missouri, 16-year-old Ralph Yarl's parents asked him to pick out his younger twin brothers. Oddly enough, he didn't have a phone with him and thought he was supposed to go to a home on 115th Street. His brothers were really waiting for him on 115th Terrace. This was 10 o'clock last Thursday night. He supposedly rang the bell at a home and then quickly got shot.
That's correct. While we generally have our cell phones handy, this particular 16-year-old boy, he was just running a few streets down from his own home to be able to pick his, I believe, twin siblings up, went to the wrong house. There's no indication he did anything other than ring the doorbell. And so that's what's really heartbreaking in this case is that the numbers of the homes that he was supposed to go to and the one that he was shot at were the same number. So undoubtedly that's what he was doing. And undoubtedly all he did was ring the bell.
Ralph Yarl, according to the man now charged with shooting him, 84-year-old Andrew Lester, was pulling on Lester's storm door. Lester, who is white, lives alone, and says he had just gone to bed when he heard his doorbell and then saw a black male on his stoop. He thought someone was trying to break in. How does that color what's happened here?
Well, so generally speaking, when somebody says, you know, there's somebody at my home late at night, in this case 10 p.m., and I was scared, we give them the benefit of the doubt. In this case, it becomes a little bit more difficult to do so because there's a doorbell ring, right? So this is not someone coming in through a window. This is not somebody that is seemingly trying to beat the door down. This isn't someone lurking outside with no purpose. There's a doorbell ring. And so that's what's really calling into question this defense for people. On the other hand, you know, we do have an 84-year-old elderly man. And so some people are saying in that moment, he sees an intruder that he doesn't know and believes that they're going to be coming in and shoots first, essentially.
What about this second shot in the forearm after the 16-year-old had already been shot in the head and then was getting up to try to get away? Lester yelling after him, you know, don't come around here. Does that change things? Or, I mean, does it matter how many times you may shoot if you're operating off of this stand your ground concept?
Yes. So generally, these are very fact-specific situations. Is it reasonable that somebody would need to shoot twice? Often in cases, we look at where the shots were. In other words, if somebody was shot in the back, that's indicative the person was running away as opposed to being shot in the front. Same thing with the number of times somebody is shot. If once is adequate, you know, why do it twice? And then this assertion that he said, don't come around here, not a great look because that's not indicative of somebody that is just trying to shoot and flee to safety. He's actually actively saying, don't come around here. That's also where people are concerned there could be a racial component there.
Alrighty, now Missouri is one of 30 states, California among them, that have stand your ground laws. So that Lester could be charged with first-degree assault and armed criminal action in Missouri. The prosecutor there had to determine that all this was not an act of self-defense. How do the legal principles at work in Missouri compare to what the assessment might have been if all of this had happened in California?
So this is kind of a slight distinction, but in California, we don't consider ourselves a stand your ground state because we don't have an actual stand your ground law. But what we do have is we do have case law and jury instructions about self-defense. And our self-defense is very similar to stand your ground laws. It says specifically in California that you can use whatever force is reasonable to defend yourself against, in this case, an alleged intruder. So, for example, if someone breaks into your home and you can tell they're not armed, there can actually be a factual question there about whether or not you're fearing for your life. If you are, you can use up to lethal force. If, for example, you're out at a restaurant and somebody challenges you to a fight, you can't whip out your gun and shoot them because that's an unreasonable amount of force. But if it was in California, I think it would be handled almost identically. Looking at the facts so far, it seems that this was just very unreasonable force, a doorbell, and then somebody is shooting immediately without any other information. So that's going to be difficult in California to assert that that's self-defense.
And then quickly before we have to let you go, this is not being charged as a hate crime in Missouri, even though it is out there that the police say Andrew Lester said to them he saw a black man on his porch and he was scared to death, and then the shooting happened. Do you feel as if it would have been charged as a hate crime in California?
It's possible. Generally speaking, hate crimes, they're going to be associated with a set of facts where we know the crime was motivated by race. So not necessarily even that race was involved or that it was mentioned, but it was actually motivated. And so that's where we see situations where people are actually seeking out crime against minorities because they're actually wanting to inflict injury on that particular minority.
All righty. Thank you so much for your insight. Definitely a case that the whole country will be talking about and is already. We appreciate you.
Absolutely. Thank you.